Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in both Texas and Virginia, and we're here with a trifecta of criminal-related stories. A verdict returned, a person goes to jail, a person wants a do-over on their trial. So we're going to cover this trifecta of stories. Let's go ahead and get started with Danny Masterson, who just completed his retrial in relation to 3 counts of forcible sexual assault that happened many years ago. This was a long fought over case. He had previously gone to trial with 3 mistrials, and now we have 2 verdicts of guilt with 1 mistrial in the 3rd count. So facing 30 to life, it seems, in these cases. Let's learn a little bit more about what happened in this California courtroom. Danny Masterson, of course, was Hyde on That 70s Show, an actor pronounced and now convicted of 2 counts of forcible sexual assault. Their jury did not reach its verdict on a 3rd charge, deadlocking with a vote of 8-4. This was a long fought over trial. The second long fought over trial, the jury itself was out for almost a week of deliberation, so spent a lot of time, I guess, thinking about it and thinking about the charges, taking their charge very seriously, apparently. And the fact that they came back with this somewhat divided opinion somewhat is more encouraging than a across the board opinion. I do personally tend to like that a little bit more when there's, a little bit of a difference in the verdicts. There's a little bit of some guilty, some not guilty, some hung. I tend to think that's a pretty good sign. The jury has really thought things through. So I'm not necessarily against across the board guilty verdicts because sometimes that's clearly what's required. But it does bring me a little bit of extra confidence when you have a jury that's out there and trying to really look at this and trying to come up with these discrete determinations. It provides some extra confidence in a correct result, at least in my mind. He faces a sentence of up to 30 years to life for the 2 charges. That's 15 to life for each charge, and those would presumably be served consecutively, though that would still have to be determined by the judge as to whether or not those are consecutive or concurrent. Shortly after the clerk read the verdict of guilty, there was an audible gasp from Masterson's family, who are, of course, seated to hear the verdict. Masterson was accused of sexually assaulting the 3 women at his home between 2001 and 2003. The jury convicted him of the assaults in 2003, but couldn't reach a verdict pertaining to an allegation of 2001. Now, what's interesting in this particular case, and I've tried to look into this and tried to research this issue on the California law and statute of limitations issues, and I think this is correct. But if someone else disagrees with me, let me know. But I think this is correct. If we're trying to only bring 1 count, all right, 1 count of sexual assault, the statute of limitations would have been 6 years. So that obviously would have expired long ago. 6 years from the date of the incident is how that is typically calculated. Okay, but California has a law that if it's multiple counts, right, then it escalates from 6 years, it escalates the penalty to a possible life sentence. It's 15 to life. And like any sort of sentence that carries a possible life sentence, this does not have a statute of limitations. So each individual count would have expired long ago. So it's only because it's a combination of counts that we're able to do that. So the problem was finding multiple victims in order to bring this case at this time. That's sort of my understanding of the thing. And also unclear how that plays as a result into the 3rd count, because it would now be a charge standing alone, but supported by 2 other guilty verdicts. So I would suspect you could still bring that 3rd count because the jury obviously mistrialed. So it's not a double jeopardy problem to bring the 3rd count again if the prosecutor want to, but it is a potential statute of limitations problem because now the count would be standing alone. Say, can you use the 2 convictions that just happened as the other acts to support the multiple acts? I think the answer is yes, but I don't know that for sure. Also, as a practical matter, with 2 mistrials in place with respect to the 3rd count and with 30 to life looking, it would seem unlikely the prosecutor would bring that case again. So I wouldn't expect it, but there's some legal trickery in there with that third count now standing alone on statute of limitations. I'm not quite 100% sure how that works, but that seems to be the best I could deduce from the whole thing. The judge ordered Masterson into custody after the verdict was read, which is, of course, very typical, rejecting a request that he remain free on monitoring pending sentencing. So, it's typically for a felony of this kind, when you're facing a life sentence, it's very, very typical that you go to custody right away. We saw, for example, in Elizabeth Holmes' case that we'll cover in a moment, that, of course, custody was delayed and delayed significantly. But in this case, not so much. Now, the defense could, of course, still make a motion in writing to have him set free while his appeals are pending, but I wouldn't expect that to be granted because of the nature of the charges, right, in this particular case. The first trial, of course, ended in November with a hung jury, with the majority voting to acquit on all three charges in that particular instance. So here, there was a unanimous 12-0, 12-0, and 8-4 to convict, respectively. But in the prior case, it was majority to acquit, which sometimes happens. So that is sort of the disposition of that thing. The case, of course, was famous as well for highlighting teachings relating to the Church of Scientology, which, like many sort of organizations before it, has tried to some degree, keep things internal, for the benefit of the organization, including these kinds of charges. So the Church of Scientology is not really unique in this respect, or at least not unique in recent memory. There are a lot of other organizations. The Catholic Church, of course, comes prominently to mind, which for a lot of time tried to prevent a lot of this stuff from reaching into the public domain and into the criminal domain. Tried to handle these things internally within the church. And there are other organizations like that I'm sure that, if we thought about, we could think about what some of those organizations are that have tried to do this kind of thing and handling it internally within the unit of the church or within the unit of the organization. So not unique in that respect, that they tried to keep it closed, and try to avoid some embarrassment to the church itself. But, notable that the church was trying to keep it secret as they had for so long. All three victims were members of the church at the time and have since left the church. So again, this is sort of not, in this sort of respect, not unique. There are other organizations that are like this and have been like this in the past in terms of trying to keep things quiet and discreet, often allowing people who are predators to continue on. So the internal mechanisms of these organizations to adjudicate things have been less than promising in many cases. They've also said the church dissuaded them from reporting Masterson to the police, which, again, not exactly atypical in that particular respect. In closing arguments, the prosecutor had argued that Masterson had taken advantage of his position as an upstart in the church to assault the victims without fear of repercussion. So again, he's a person of prominence. He's a person of importance. He's too important to turn in. He's our bishop. He's our father. He's our elder. He's our whatever. Too important to throw up the whole internals of the church. So that he used a position of power to gain this leverage. Not atypical. Not unexpected. A lot of people who are like this look for positions that are like this, and it doesn't particularly hurt when the organization in question likes to keep their dirty laundry private because it allows them an opportunity to thrive. So yeah. Like all predators, the defendant carefully sought out his prey. The church taught his victims that the sexual assault isn't sexual assault, that you caused this, that the victim is at fault, and above all, you're not allowed to go to law enforcement. What better hunting ground? In Scientology, the defendant is a celebrity and untouchable. Defendant's attorney argued the prosecution invoked Scientology as a way to distract from inconsistencies in the victim's testimony, which, perhaps fair enough. So, the degree to which all that is true, of course, is an issue of fact as to whether or not Scientology was responsible, to the degree to which their inconsistencies can be explained by that, the degree to which it's being merely used as a boogeyman to impeach someone, using basically flipping the whole thing on its head, rather than use it as a shield, use it as a sword. So using whatever negative reputation or predations are assumed about the church at large to speak to this particular member. So turning that whole thing on its head. So the degree to which that's true, of course, is a question of fact. And one of the reasons, perhaps, it was a mistrial in the first place, and one of the reasons that it perhaps took the jury as long as they did to come out with a verdict. The defense attorney asking, why have we heard so much about Scientology? Could it be there's problems otherwise with the government's case? It is a reasonable argument from the defense, of course. Maybe we are in the same vein as if this is the Catholic Church. Maybe we're simply saying Catholic Church bad, nefarious, secretive. Therefore, this person is guilty. So using kind of a guilt by association argument. So perhaps that's what's going on, but that's part of the issues to be resolved by a jury. The defense made their arguments, the prosecution made their arguments, the jury reached their conclusion as a matter of fact, which is kind of what juries do. Scientology, of course, was also a prominent feature of the first trial. The first major difference between being the two trials relating to the issue of drugging. In a first trial, the woman testified that they felt weak or woozy and low memory. But the prosecutor did not overtly claim they put something in a drink to disable women, which, to be fair, fine. A significant number of drinks that are tested, from people who think they've been drugged have no drugs in them. So a lot of times people say, oh, I've been drugged, my drink was spiked. And it is a significant percentage of them, the vast majority of them actually, have no drugs in them at all. It's just the alcohol or the other situation. People have a tendency to sometimes, get that what's called a nocebo effect. It's the same thing as a placebo effect, but in reverse. The placebo effect is by believing something will help you, it will. Use that in drug trials. The reverse of that is called the nocebo effect. And if you believe something will harm you, it will. So if you believe that your drink has been spiked, then you will act as though your drink has been spiked. And also, incidentally, this has been sometimes tested with completely non-alcoholic beverages, that people believe are alcoholic, so there have been scientific experiments where, someone will host a kegger, or a party, but none of the drinks are alcoholic, but people will behave as though they're drunk because they believe that they're drunk. So there's definitely some interesting research on that when it comes to psychological effect and people's ability to believe things. So a lot of drinks that people think are spiked are not spiked. That isn't to say that some aren't, but most of them aren't. Most of the time, it's just the alcohol and then the SIBO effect. So her feeling a little weak or woozy doesn't necessarily mean the drink was spiked because, well, that's how human psychology sometimes works. In the retrial, the prosecution changed course and argued that there was, in fact, a drugging of the drink, saying they're all drugged. The defendants drugged his victims to be in control. He does this to take away the victim's ability to consent. This is not about consent. This is not about misunderstanding signals. When he drugs them, he's able to completely physically control them. You don't want to have sex, you don't have a choice. The defendant made that choice for the victims and does it over and over and over again. Incidentally, for whatever it's worth, there's obviously a legal distinction to be had between being intoxicated and being unable to consent, right? So merely because you're intoxicated, merely because you're drunk, doesn't necessarily mean that you don't have the ability to consent, right? It has to be, in terms of the law, right? You have to be so gone that, right, you're unable to form the intent. So this is like why merely drinking, like as you're signing a contract, doesn't necessarily nullify the contract for the same reason, right? Just because you're slightly under the influence doesn't mean that you're too under the influence to consent. So there is a distinction to be had. But obviously the question is, where on the continuum are they on that issue? Again, a question of fact for the jury, right? So had they been drinking? Had the drink been spiked? If so, did that cause their behavior? If so, did that cause their behavior to a degree that inhibited or interfered with their ability to form the consent? All questions of fact. You tease this out before a jury, let them decide. They decided, so that's the relevant verdict. There was a counter that there was no evidence, such as toxology, that would show drugging. He also noticed there was no reference to drugs in the charges themselves, which they don't have to be. The issue is there was no consent for the sexual assault. One of the reasons would be that they were unable to form the consent because they were drugged. So you don't need to necessarily say that in the charging document if the facts support it, and you can support it circumstantially. So was there alcohol in that drink? At all? Was there something else in the drink? At all? Did either of those things reduce their ability so much they couldn't legally form the intent? These are all questions of fact. And the jury said yes. So there you go. And their deliberation verdict, their time, shows, I think, that they took these things seriously. And so between that and the first mistrial, I'm inclined to somewhat take their view at first glance. They seem to take their job seriously. One of the women reported the crime to the LAPD in 2004, but the prosecution did not file charges at that time. The case was revived in 2016 due to this combination thing. So she initially brought charges. They decided not to bring it. That case legally expired in 2010 because of the statute of limitations. Well, assuming it happened in 2004, which isn't said here. So assuming it happened in 2004, it would have expired in 2010 on its own. But because we're now bringing it in combination as part of a concert and plan, we're able to bring it together. The prosecutors were able to file charges under what's called the one strike law that extends the statute of limitations in the case of multiple assaults, which I've been talking about. So yes, for one case, 6 years statute of limitations. But because it carries a possible life sentence because it's multiple, then there's no statute of limitations, which is very typical. There was an argument that the women had tweaked their stories to fit the narrative after meeting each other and discussing the case, which, also is possibly true, right? When victims meet, possibly they influence each other, and possibly they cause each other to remember things that didn't happen, or they influence each other's in an improper way, right? So that's why you bring all that out at trial, right? They had met each other, they had an opportunity to coordinate. Okay, did they coordinate or not? What do you believe beyond a reasonable doubt? So you bring that all to light and you let the jury sort it out. That's what you're supposed to do. A woman has her absolute right to say no, they argued, but when it comes to no 16 or 17 years later, that is a scary scenario, which, to be, completely fair, is a bit scary, which is one of the reasons you have the statute of limitations in the first place, to the degree that you do based on various states. Because, evidence gets old, memories falter, people forget things, people remember things that don't happen, all the rest of it. But those are all things that, the state of California has thought in this multiple assault crime thing should not be allowed to get past the statute of limitations. And so this was brought, and we have 2 counts of conviction that led to 15 to life. So all that good stuff. All right. So I also want to talk a little bit about the civil cases in this case, because it's also very interesting legally. All right. So all 3 women, of course, as you would expect, are suing Masterson as well. Now, what was interesting is that all the women, as part of being a member of the Church of Scientology, said that in the event of any dispute, this is a little, what would you say, a little bit imprecise, but it will get the point across. The women had all signed an agreement, an arbitration agreement, in the view of the church, that said in the event of a civil dispute for any cause of action that arises out of another member being a member of the church, and again, the details are a little bit vague. It's been a while since I read the arbitration agreement. But in the event that you have a civil dispute that arises out of something to deal with the church against another member of the church, it must be submitted to arbitration. All right. I believe also the arbitration agreement itself appointed the church as the arbiter as well, which, they are not the party being sued, right? It's against another member of the church. So the church itself would be the arbiter, although I might be mistaken on that particular detail. It's been a while. Anyways, so as we know from law that we've discussed before, people generally have the ability to sign arbitration agreements for all kinds of things. And those are typically binding, right? So this was a huge issue that delayed the civil case for a very, very long time, because the church said, or maybe it was Masterson said, either way, one of them said, right, there's a binding arbitration agreement in place. You can't sue me over that. You have to go to arbitration and, let the process work itself out. And what was interesting, I think it was last year, the Ninth Circuit Court of Appeals finally decided the issue and decided that they could withdraw themselves from the arbitration agreement, which was an interesting decision by the Ninth Circuit, incidentally. So they had said that the arbitration agreement was part of their membership of the church, and that by deciding to no longer be members of the church, they were also no longer bound by the arbitration agreement with the church, which was an interesting decision from the Ninth Circuit on the technicalities of the arbitration agreement. So by withdrawing from the church, they withdrew their consent to be bound by the arbitration agreement the church had conducted. The church obviously strongly disagreed with that, but they lost in the Court of Appeals. So that was a huge issue with the delay, because can we even sue you? And then, of course, the rest of the delay was due to the ongoing criminal trials, because they will tend to take a back seat to criminal cases because of due process reasons relating to the criminal case and other reasons. So it's very, very typical for civil cases to take a back seat. So between the arbitration agreement and does it or does it not apply, and it taking a long time to determine no, and the criminal case, the civil case was long delayed. But that case is no longer binding, and so they can go forward with their lives and go forward on that. So that should be exciting relating to all that kind of stuff. Okay. So that is everything there is to know about Danny Masterson. Let us briefly discuss Elizabeth Holmes, who finally went to prison. It took a hot minute for her to go to prison. Elizabeth Holmes finally reported to prison in Florida to serve her 11-year sentence for the massive security frauds relating to Theranos, the blood magic machine, which would take a couple drops of blood and determine every illness you've ever had ever. But it didn't work. It was a massive scam. She had been fighting actually going to prison for some time, and it's been a hot minute since she'd been convicted, but she finally reported to prison yesterday and turned herself in. So she is serving her time. Very exciting. She turned herself into a low security women's prison that is a camp style prison, which is the lowest security that the federal prison system has. So her accommodations aren't too bad. It doesn't have, it has a basic ass fence, right? It has a fence around the yard that you might see at a person's home. It's just a simple iron fence. It's about waist high. You could easily crawl over it. There's no barbed wire. There's no guards. There's no tower. There is a fence that's about waist high because it's low security. And if you escape from the prison, obviously, well, the federal government's going to have more words with you. So people have a tendency not to escape, but it is not exactly, Alcatraz over here. She had been convicted on wire fraud and counts of conspiracy relating to wire fraud. She had received her sentence in November, and it finally took until now. It took 6 months for it to actually start serving her time. It was a hot minute. It was a hot minute. Video that was shown showed Holmes walking into prison to turn herself in. Having dropped out at age 19, she founded the blood testing company, but it didn't work. She raised about $9 billion. She became the youngest woman self-made billionaire before her earnings turned to zero because it was all a massive scam. She had some high prominent officials in her board, including Henry Kissinger and George Shultz, among others. She was considered at a time to be the next Steve Jobs, but it was all a massive fraud. A former executive who was also in a Holmes has been serving time as well relating to the same underlying incidences as well. He began serving his time for 13 years in April. Holmes had been living in the San Diego area with her son, daughter, and father. Her son was born in 2021, a few weeks before trial began, and her daughter was born February. May have tried to, using very old school parlance, plead her belly to get out of criminal responsibility, but it didn't work forever. She has admitted to making mistakes but denied committing crimes. So Elizabeth Holmes finally in prison at last. So she's serving very, very cushy time, all things considered. Federal time is considered easier time than state time, and she is serving the easiest federal time that there is. But still, it's 11 years, so yeah. And she has to serve 85% of her sentence, incidentally. So she can get out early on good time behavior. So She has to serve what, about 9 years? So we'll see how that goes. So all that good stuff. All right, finally, we turn our attention to Lori Daybell and the motion for a new trial. Lori Daybell, as you will recall, was convicted of murdering her own children. She'd prefer to have a new trial. And I thought maybe we could discuss her motion for a new trial and discuss what it says. And it's not really very good, in my humble legal opinion. I think there were other grounds that are better and that are not here, for example, but we'll discuss that as we go along. So let's say what we have now. So the defendant, through their attorneys, would like a new trial very much. The relevant rule says that a court may vacate any judgment and grant a new trial on any ground permitted by law, and states the motion must be filed within 14 days. This has been filed within 14 days. The statute in question permits the court to grant a new trial if the jury has received any evidence out of court other than that resulting from the view of the premises, and that when a court has misdirected a jury in a matter of law or has erred in decision of any question of law arising during the course of trial, and we'll get to that, and when a verdict is contrary to law or evidence. So, okay, let's see what we got. Issue number 1, the court misdirected the jury in a matter of law as it relates to jury instructions on conspiracy. Okay. The indictment filed by the grand jury states the conspiracy is Chad Daybell, Lori Vallow, and Alan Cox, and other co-conspirators, both known and unknown. The language clearly states at least 5 people entered into the conspiracy. I don't know about that. I appreciate your use of the word "and" to mean that all those people are involved in the conspiracy, but I don't think that's the best way of reading it. But thanks. The trial court, however, at the government's request, allowed the trial to consider conspiracy of only 2 people: Lori and Chad, Lori and Alex, or Chad and Alex. Which, okay. So yeah, I mean, a conspiracy by definition is an agreement between any 2 people for an illegal act and an act in furtherance of the conspiracy. So I would think that this would be fine. That these are the 5 people who maybe were involved in the conspiracy. Of course, we've only named 3 by name, but okay. And they were allowed to consider all those conspiracies. The change of the definition of conspiracy from the grand jury to the trial jury completely changed the complexity of this case by allowing the insertion of "and" or language. This is totally a matter of state law in terms of this. I'm going to assume that "and" here can be read as "or," and this argument is really lame because I assume it's really lame. For 2 years, the defendant has been put on notice that the conspiracy involved at least 5 people. The notice was clear from the language of the indictment. To have the government and court permit a conspiracy of just 2 people instead of 5 was prejudicial and unlawful. I don't think so, Tim. I don't think so. The conspiracy is by its nature an agreement between 2 people. Here are the people that were part and parcel of the conspiracy. Any 2 of them will be fine. I don't think that that's changing the indictment, but okay, fine. Number 2, the court misdirected the jury in a matter of law as it relates to the amended indictment. At the close of evidence in this case, the government moved to amend the indictment 2 years after it was filed for a clerical error. The amendment in question was not a clerical error, but changed the statute in the definition of grand theft. Yeah, that's a big problem. That is a big problem. We cited the wrong statute in the indictment. That's a pretty big oopsies, right? That's not a clerical error, right? And versus or, okay, whatever. But here we cited the wrong statute. It's like literally the charge. We are charging you under this statute. Oops, we really meant this statute. That's a pretty big oopsies. The amendment is not a clerical error, but changes the statute. Yeah. Repeated attempts by defense to remand the indictment last year were objected to the government and denied. The court should likewise deny the government's request to amend. I don't know how the process to amend indictments go, but I'm going to assume it has to be amended by the grand jury because the grand jury brought it in the first place, because this was a capital murder case, right? If this was an information which can be brought by the prosecutor alone, then presumably it could be amended by the prosecutor alone. because the prosecutor was the one who brought it in the first place. But because this is an indictment, which I'm going to assume is required under Idaho law, because this is a death penalty case, because it was a grand jury, only a grand jury can fix it. And this is not a scrivener's error. This is a pretty big screw up. Whether the language of the grand theft charge includes intent to deprive, intent to deceive was an element of proof to be determined by a jury. Yeah. Which one is it? Intent to deprive or intent to deceive? Those are not the same thing. Intent to deprive is I'm trying to take a thing from you. Intent to deceive is I'm trying to trick you. Those are not the same thing. Those are not the same word. Those are not synonymous words. You've changed one of the elements of the crime. That's a pretty big screw up. So it should not have been amended by the government. Yeah. Also, incidentally, while we're at it, the whole count 1 and count 3 for the combination conspiracy for the murder and grand theft are not legally cognizable. So also that. But I'm not sure why we're not mentioning that now, because that would be an error of law. So counts 1 and count 3 do not legally exist. There is no such crime. Also, even if it was a crime, you messed up which one it was. So just doubly wrong. You really were pretty sloppy on this one. That's pretty bad screw up. All right. So yeah, that's okay. Number 3, a jury interview revealed the jury's instructions were confusing and knew of evidence not submitted to the jury. Get out of here. Get out of here. You want to argue the jury didn't understand the instructions? You want to understand that they had some evidence or information from outside the court process? Get wrecked. Get wrecked. Unless you can prove they did something completely legally improper, or there were bribes or something, or, someone was feeding them information in manila envelopes. No, not a chance. This is not a good argument. You shouldn't bring this argument. This is dumb. Juror number 8 was interviewed by East Idaho News in Boise. The juror and the reporter were very respectful of the process. Roughly halfway through the interview, an interesting discussion takes place for 2 minutes. This is so stupid. The reporter, having seen all the evidence, all the thousands of hours spent, how would you describe the efforts of law enforcement? The juror, they did a good job with what they had. I don't know you could ever train for something like this. I think they did a good job with what you had. You question some things that happened. I'm sure there's a reason for it. You question some things that have been done differently early on. Would any of us be there? Yeah, fair enough. Reporter, do you have an example of those things? Juror, we didn't consider this during our deliberations, but it was clear to us the instructions were clear. Arizona evidence and testimony is only for demonstrative purposes. The reporter, sure, yes. And we were all very, very respectful of the rule. The directions were given. But now being removed from that, I think the police department in Phoenix had some significant red flags. They've been followed up, maybe we're not here because maybe, this wouldn't have happened had Arizona not screwed this up. So maybe if these people had been caught earlier in their vast criminal web of journey, maybe we wouldn't have been here because this crime wouldn't have happened at all and they'd still be alive. Okay. Do you mean after Charles was shot? Before and after? Before and after, yes, you're right. Before he was shot with the body cam. Juror nods in the affirmative. Reporter moves on. You've got to be kidding. You want to try to squeeze something out of this? You want to try to squeeze blood out of this stone? Really? Get wrecked. Get wrecked. The question and answer between the reporter and jury makes clear the evidence permitted under the rules is confusing to the jury. Get bent. The defense continually objected to the evidence. This is a good example why. Arizona evidence was not for demonstrative purposes, as the juror stated and reporter agreed, but was evidence to show some reason other than character. You have got to be kidding. You have got to be kidding. The juror, who is not a lawyer, used slightly the wrong word. You want to pin your hopes on this? Get bent. Get bent. The juror used slightly the wrong legal vernacular. Ooh. Oh, that totally shows the jury was doing the wrong thing. You have got to be kidding. To confuse demonstrative evidence and character evidence is easy to do. Hence, defense objections should have been sustained. No. Just no. Sorry, no. The second problem with the jury's comments are that Charles Vallow's statements to law enforcement were not part of the evidence in this case. The juror and reporter refer to it, but it wasn't presented in court. Well, since the juror has left court, they've had the ability to consider other things other than what was offered in court. So, yeah. We can only conclude the jury relied on the information not presented in court to reach the conclusion that Arizona dropped the ball and should have done more, even before Vallow was shot and killed by Cox. The actual recording of the interview is available. No, this argument is totally stupid. This argument is totally, absolutely dumb. First of all, even if the jury did have this outside information, that's a voir dire problem, and that's on you. Second of all, even if so, no. Third of all, they've had the ability to see things outside the trial since it ended. Fourth of all, just no on principle. This argument is really, really dumb. And I don't like this argument for tactical reasons. Because when you bring weak shit in, it has a tendency of making everything weak, right? When you have a spoiled apple, that spoils the bunch. The good apple doesn't make the bad apple better. The bad apple tends to make the good apple worse. So I don't like this for tactical reasons, because this is some weak sauce shit argument. Was the jury like consulting the Bible during deliberations? Did they break out a Ouija board? Did they try to conduct a seance in the jury room? These things have all happened in other trials, by the way. Did someone try to bribe them? Did someone hand them a secret manila envelope? Information we didn't want you to know. Other than that, get wrecked with this line of argument. This is some dumbass shit. All right? This is some dumbass shit. So number 3 is totally stupid. Number 2 is much better. Number 1, no. So number 2 is the only one here that makes any sense. Now, what's interesting here is that reason number 5, right? When the court has misdirected the jury as a matter of law or erred in decision of any question of law arising during the course of the trial. Any question of law. Any question of law. So why, in this motion for a new trial, are we not mentioning, hey, counts 1 and 3 don't legally exist? There is no such thing. Are we waiving the issue by not bringing it up again? I honestly don't know. If we're in federal court, I know the answer is no, because the US Supreme Court just told me. But I don't know about how this works in Idaho. So why are we not raising the issue of counts 1 and 3 don't exist? They never existed. You've hallucinated them out of nowhere. Why are we not raising that issue? And also, why are we not, when the verdict is contrary to law, why aren't we raising the issue of the jury being exposed to 30,000 gory photos, which violates at least a couple different US Supreme Court cases? So this motion is really undesirable from a couple angles. 2 is the only issue. There are other issues that exist, and 3 is just legally dumb. 1 is less dumb. I mean, and versus or, I guess, maybe. I doubt it. I doubt that. But 3 is, the jury didn't do it perfectly. Ooh, tell me another story over here. Tell me another one. The jury was not perfect. They didn't use exactly the correct language, exactly. They were slightly confused on a concept. This is an error of law that must be corrected. You have got to be out of your mind. So I don't know why some of the other ones are here, because I would be asking for a new trial. Number two is good. I like that. But I'd be asking for a new trial because counts 1 and 3 don't exist. And I'd also be asking for a new trial because the amount of gory photos was so incredibly prejudicial that it has to do a do-over. And I'm citing US Supreme Court cases for that proposition. So I don't know why Archibald is raising the issues he is and missing some ones that seem kind of obvious. So maybe I'm missing something, but that's what I see. All right, great times. So yeah. So that's all the things I see. Let me read your super chats. as well, because I saw there was one that came in, and let me find it and I'll read it. Super chat messages. Uh-oh. Are my super chat messages not updating anymore? I think my script broke. I have to go into YouTube's backend now and get it. That's all right. Yeah. I had a script that was supposed to save them in a Sheets file, but it broke and I hadn't noticed. So I'll go get into my backend and get it that way because I'm pretty sure I saw a super chat come in. Let's see. Where is it? All right. So I think it was just the one. Yeah, just the one. Stilled Rocco gave $5 to say, so if I were to quit a job, I wouldn't be under the authority of the arbitration agreement. I did choose to leave the organization. Yeah, that was kind of the argument the church made as well. That they shouldn't not be bound just because they left for kind of the same exact reasons you were intuiting. That right, if you have an arbitration agreement with your company and you leave the company, the arbitration agreement would typically continue to run. Um, the Ninth Circuit, at least in part, based their reasons on freedom of religion. So they said that this is different than a employment case because freedom of religion allows a person to choose their religion, and because the nature of this arbitration agreement was religious in its nature, and because people have freedom of religion and people have the right to change their religion, that the court could not enforce the arbitration contract as a matter of policy because it would inhibit people's free choice of religion was part of their rationale. Now, whether you buy that or not, under the Federal Arbitration Act. I don't know what to tell you, but that's what the Ninth Circuit said. So fun and exciting. What else can I answer for you as long as we're here? Thank you for the gift memberships, by the way, from It Was a Dumb Name Show. I changed it. Thank you for the gift memberships. That is appreciated. You feel stretched? I didn't write it. I'm just reporting it to you. Hit the like button while you're here. Make sure your gift memberships are on and all that. Crow Minion gifted 5 memberships. Thank you very much, Crow Minion, for the 5 memberships. For a new trial, with death penalty come back? I honestly don't know. I mean, logically, probably. If we really went back to ground, then probably, because the prejudice, which was at least time-based, would be cured. So if we do a new trial, can we get the death penalty back? Yes? Question mark? I think. Yeah. Lily gives a gift membership. Thank you, Lily, for the gift memberships. They do really help the channel and the channel growth. How many appeals does Laura get? One as a matter of right. One as a matter of right. Everything beyond that is discretionary. So she gets one to the Court of Appeals by as a matter of right, and then beyond that, you know, she can ask the Supreme Court of the state for intervention, and she could also try collateral for a habeas corpus to the feds. But because of the effective Death Penalty Act, those are really, really hard. So one as a matter of right is the right answer. Brentwood Chic gives 10 gift memberships. Thank you very much. I am feeling better. Thank you for asking. My last sickness was just a 1-day thing. So it went away the next day. But thank God for that too, because the last one went on for a while. Did I go to the gym today? No, today's my day off. I only go every other day. I'll go tomorrow. Does Lori have a chance for appeal? Yes. Assuming the issues are properly preserved, I think that the prosecution very crossed the line when it came to the demonstratives for the stuff. Like, there is case law on that issue with the blood and guts, and it went on for a really long time. So I think, and also between that and Archibald's absolutely train wreck of a closing argument, and also that the fact that the judge himself said there was prejudice that already occurred, was whether you agree with that or not, he said it's true, and other little errors along the way, and also the fact that there was issues dealing with the judge's consideration of sealing the court record that wasn't done properly. Yes, I think Lori has pretty decent odds on appeal. I think her odds on appeal are pretty good. So I don't think it's a stretch as much as one. But the jury was confused is a really dumb argument. The court of appeals is going to do exactly what they did with the Chauvin case, right, on appeal. Like, this is the same exact problem. The court of appeals didn't want to talk about the venue issue. So at the court of appeals on Chauvin for George Floyd, Chauvin's attorney raised a whole bunch of issues. The venue issue was by far and away his best issue. He brought up other issues, including issues with the jury, which really aren't winners. And what did the court of appeals want to talk about? They want to talk about the issue with the juror. That's all they wanted to talk about. It's a total nothing issue. It's not going to go anywhere, but it allows them to talk about an issue that they technically raised and not talk about the venue issue, because the venue issue is really, really uncomfortable. So I think maybe on this particular occasion, maybe it's a difficult call as an appellate attorney, because it's like, do you want to raise every issue that's viable, or do you make the hard decision to not raise a valid cause of action to force them to pay attention to a different cause of action? That's a tough decision to make. If you have 5 issues that are viable appeals, do you raise all 5 or don't you? Or do you just raise the one because it's what I really want you to focus on, and you abandon the other 4? That's some break out the big brass ones moment right there, right? That's break out the big brass ones. Because if it goes south, right, your client can always say, why didn't you raise the other 4? We would have won on those. So it takes some big brass ones to let 4 good arguments go to force them into a place that you want to be. Oof. But in the George Floyd case, their attorneys chose to raise issues that allowed the Court of Appeals to deflect. And Archibald, I think, is doing the exact same thing. So Archibald may not have the big brass ones that he needs on this occasion. Sandra Ramirez gives 20 gift memberships. Thank you, Sandra, very much for all your support. It means a whole lot to me. Thank you very much. It's also like that decision the prosecutor has to make sometimes. When they have lesser includeds, like murder is like the most common example. It's like, we're going to charge murder, but the jury can also consider manslaughter. The jury can also consider this. The jury can also consider this. Because murder typically includes other things, right? To commit the murder usually means that you committed other crimes. You necessarily committed other crimes in order to commit the murder. So those are lesser includes, right? The murder requires proof of other crimes. So those other crimes are also charged, right? Typically, like, you're charging the top count and also everything that comes along for the ride, right? So it's like, okay, we're charging you with murder, jury. But if not murder, you can go manslaughter. But if not manslaughter, you can do this. But if not this, you can do this. You can do this. You can do this, right? So you have this in the alternative. And then it's like one of those decisions for the prosecutor when you break up the big brass ones. Like, do you want me to instruct the jury on lesser includeds? No. Top count or bust. All or nothing. Do you want to or do you not want to? Big brass ones. Go for everything or nothing. Force the jury to make a decision. And if they decide against you, well, You just lose. Same kind of thing, man. You know, we're playing some high stakes games over here in lawyer land sometimes. We play some high stakes games with people's lives on the line. You know, pony up to the table, baby. What are you willing to bet? You know, woof. What else can I answer for you? We can talk about anything you like. That's sort of in the news. Stories I've covered recently, live streams I've covered recently, anything legally related. I do have 2,000 videos on my channel. You have any questions about any of those? Well, my opinions on the Little Mermaid contract, that was a lot of fun. That was a lot of fun. I enjoyed with Danny and Direct yesterday. That was a lot of fun. It's like as we're trying to interpret this contract with the Little Mermaid with Ursula for the Kingdom Under the Sea. I'm like, wait a second. How are we interpreting this contract? Is this a contract for goods? Is this a contract for services? Is this UCC? Is maritime law thing? Should we view this as like a surrogacy contract? Is this like the case of Baby M precedent that we're bringing into this thing now? Is unconscionability? We have issues with consent. We have issues with performance. We have issues with ambiguous terms. We have issues with a minor. All kinds of issues in this case. Like this is, it's like, how are we viewing this contract in the first place? It's fun, man. Am I covering the New Jersey shit show regarding firearms? I sure am. And I also covered today where New Jersey Supreme Court threw out that case for the roadside stop. That was fun. EDB covered it as well. That sounds fun. The Corey Richins case. Well, what is Corey Richins? Family Feud verdict. What's a Family Feud verdict? Oh, the guy who was on the Family Feud. Oh, okay, that's right. We covered that case. Corey Richins. Who is a Corey Richins? Someone who killed someone using fentanyl. Ooh, fixing a Moscow mule laced with fentanyl. Ooh, that's exciting. Well, poison is a woman's, weapon when it comes to murder. Fentanyl murder, that's kind of cool. I don't know about that one. Did I enjoy the Supreme Court wrecking the EPA? I sure did. I sure did. That was fantastic. Thank you, Brentwood Cheek, for the gift memberships. The family verdict came in. Is it guilty? He going under the sea? Yeah, guilty of all counts of murder. Well, survey says. Wait, I actually have a sound for that. Survey says. Survey says. Survey says. Gotcha, bitch. Oh, good times. She killed her husband and wrote a book about coping with his death for her kids. That's pretty hilarious. That's different. I'm having some fun. Yes, I'm having a good time. I'm enjoying hanging with you guys. 300 of you here is cool. I like having 300 of you here. Family Feud verdict. Let's read this story real fast. We're not going anywhere. Let's cover this case. All right, what's going on with this thing? Timothy Lifnick. Jury reached a verdict. An Illinois jury found Timothy Overhill guilty of all counts of murder of the former Family Feud contestant, accused of killing his estranged wife, an accomplished nurse and fixture in a local church, amid a grueling divorce and custody battle. The Family Feud became very, very, very real. Yeah, for the 331 of you who are here, by the way, I do a stream pretty much every weekday morning, unless I'm sick. So, for the last 5 weeks or so, I think I've missed 3. So we're doing pretty good. 5 days a week, 9 a.m. Central, 10 a.m. Eastern. We do a stream every morning. We post videos from it. It's great. And all the rest of it. And it requires a lot of work on my part, incidentally. I was complaining in the Discord because of how much work it takes, because I was feeling really tired, because it was like having trouble getting everything done. But I do enjoy it, and you guys give me energy. So I hope you like it, and I hope that you'll tune in. It kicks ass. So 10 a.m. Eastern time, 5 days a week. It's great. Family Feud over here, who lived about a mile away from his wife, was accused of breaking into his wife's home through a second-story window and shooting her 14 times. Prosecutors alleged that he researched ways to commit a crime on Google. You need to Google for that? Rode to her house on a bicycle, pried open the window with a crowbar, and shot her dead. Did you take the ladder with you on the bicycle? Because if so, that's pretty impressive. Or was the ladder already there? Where'd the ladder come from? Jury selection took place last Monday. The trial lasted over a week before closing arguments. Here we are in happier times. They look happy together. I'm a bit of sucker for true love. I am a bit of a sucker for true love. And when you see a family together like this, it breaks a little piece of my heart. It really does. I'm a bit of a sucker for the dream. I'm a bit of a sucker for the wife and the 2.5 kids and the house and the, together till death do we part thing. So anytime it doesn't work out, I'm a little bit sad. Here we are in happier times. It's very, very sad for everyone. The father found the body on February 23rd, according to prosecutors. Police arrested the husband almost 2 weeks later after they served a search warrant at the home. In court, prosecutors revealed that investigators retrieved dozens of shell casings in the basement that they found were the same gun. Police didn't find the murder weapon, but a handgun was missing. And forensic experts said it was among several weapons that could have matched the casings. So we know he has a gun. I guess it's Illinois. So perhaps it's because the gun was registered, or we otherwise had purchase records. Thank you, Lillian Wright, for the memberships. It's really, really appreciated. Tim was a college football star and contestant on Family Feud who killed his wife. The sister also testified that she received a text message that read, "If something ever happens, make sure number one person of interest is Tim," which really, you don't need to tell the police that. They know that anyway. It's most murders are someone close to you. So, the husband and boyfriend, or the wife and mother, as the case may be, are going to be pretty top list at the suspect pool. I'm putting this in writing that I'm fearful he'll come harm me or try to do something that takes me away from the kids. He's already lied multiple times to paint himself as a victim and me as the perpetrator when it's absolutely the other way around. Well, sounds like a Family Feud to me. Shh. The defense attorney counted there wasn't enough evidence to prove beyond a reasonable doubt. Okay. The prosecution's case was dripping with sympathy and lacking hard evidence. Okay. The state has come up woefully short in their quest to prove Tim guilty beyond a reasonable doubt, citing lack of DNA and surveillance video. I like that. That's kind of what I thought that Lori Vallow's attorney should do as well, right? This is not a bad strategy. This is a good strategy, right? If you don't have anything else to do, One of the things you can do is point to lack of any evidence that the state has, even if it doesn't necessarily make sense, because it's like they don't have it, right? So for Laurie Vallow, for the closing, right? Because you don't have a lot to work with, because your client is absolutely guilty as shit, right? But what you sort of always have, like the last card in the defense attorney's deck, right? You always have the last card. And the last card is you remind the jury that the state has the burden of proof beyond a reasonable doubt. You remind them how high the burden of proof is. You remind them of how important it is. You remind them of beyond reasonable doubt, and like you compare it to all the other kinds of levels. You say how important it is because we're taking someone's life away. And then you kind of do this. You point to lack of any evidence they have. So what can you do in Laurie Vallow? Well, they don't have a videotape of the murder. They don't have an eyewitness of the murder, and whatever else they don't happen to have, right? As the case may be. You know, I'm not sure what else they didn't have, but to the extent it's true, they don't have DNA, they don't have fingerprints, they don't have hair, they don't have forensics, they don't have this, they don't have that, or they did this, or they latched on, or they focused on this to the exclusion of other possibilities, or anything you can latch onto, right? And then you end you end by reminding the jury again about the importance of reasonable doubt, and someone's life is on the line, and you can't bring the person dead, but that shouldn't mean back from the dead, but that shouldn't mean that you convict the innocent person. And that's sort of your last resort as a defense attorney. So this idea is the right idea, right? If you can't do anything else, this is what you do. Apparently the woman was a fixture in her local community. She graduated valedictorian, good for her. She began her career in pharmaceuticals, but finished nursing school in time for start of coronavirus. Yikes. Bad time to start a nursing career. As a nurse, she received an award for service to her patients. So, yeah. So, all that stuff is happening in that case. So, we have Tim over here and his wife. A sad, sad tale. Why couldn't those crazy kids just work it out? Who's worse from a defense perspective, Laurie or Chandler? Chandler, I think, is worse. Yeah. No, they're both pretty bad. No, Chandler's worse. Yeah. That we have video of the fireplace sparking in the house because of the fat drippings from the body parts that are in the fireplace, and the fat, when it liquidizes and hits the fire, sparks, and you have pictures of it with it happening. And also the tools were found in the yard of his girlfriend's mother, and also bodies were found in places that he was frequented, that we had photographs of. And also the timeline with, like, can you get me some soda, mom, so that I have the ability to kill father before I kill you, or maybe it was the other way around, as the case may be. Chandler, I think, was worse. Although Laurie Vallow, we found the bodies in Chad's backyard, which isn't a great place to dispose the body. At least Chandler didn't bury them in the yard of his own house. I think Chandler might have been worse. It was pretty bad. Although then again, Laurie Vallow did go on a honeymoon immediately after her kids went missing without apparently any concern in the world. Which, dude, nothing puts me in the spirit more of a honeymoon and getting married than my own kids being missing. Holy shit, dude. What's that all about? I don't know. I think I'm going to go with Chandler. I was surprised that Chandler didn't try to squeeze more out of the girlfriend in terms of being there and all the rest of it. There were some opportunities not there. I guess the defense counsel thought in the end it would backfire. Chandler might be worse. They're both pretty bad. Also, Lori Vallow also has other murders beyond. I always, and because it's a whole like corkboard of murders. So like there's these children and like the ex-husband and another guy with the attempted assassinations in multiple states. It's pretty messed up. They're both pretty messed up. Also, the Mormon rom-com fiction, is that a plus or a minus as we're evaluating these two people? Are we crediting them? Is that a factor in aggravation or mitigation? That Chad Daybell wrote this wonderful Mormon post-apocalyptic fiction, which I have on my Kindle because I bought it as a business expense. Is that a good? Is that a plus or a minus? We could read some more of Chad Daybell's writings. We could open up a random page in a random book and read some more of his writings. Was it a good read? No, absolutely not. No. Brentwood Sheik, thank you for the gift memberships. That's super appreciated. Just a friendly reminder again, in the mornings, every morning, 10 a.m. Eastern, 9 a.m. Central, sometimes 15 past the hour, rarely 30 past the hour, depending. But we hit it every morning, 5 days a week, unless I'm ill. When we read the loin fire memo, that was pretty solid. That was pretty solid with the loin fire. I'm not sure we can ever top loin fire again. With the blessings and the ceiling. Wow. Good times. Yeah, it's still on my channel from like a year ago. If you want to go and watch me, I think it's called The Romantic Text Messages of Lori Vallow and Chad Daybell. You should be able to find it pretty easy on my channel. If you just type in their names, Lori Vallow and Chad Daybell, text messages, I'm pretty sure you'll find it. It's about a year ago at this point. What else can we talk about? I really enjoy you guys being here. Thank you, Sandra, again for the 10 gift memberships. That's really, really kind. Really appreciated it. Well, I suppose that will end our stream since there doesn't seem to be anything more to talk about right now. But we've covered a lot of really great ground today, and I really enjoyed hanging out with all you guys. And I really do appreciate all the gift memberships and super chats and all the rest of it. It's really, really fun. So I really do appreciate every one of you who's here. Just a reminder to please make sure that you're subscribed to the channel. You may have been unsubscribed, possibly since we've been talking, because YouTube does that kind of stuff sometimes. So make sure to hit the subscription button and all the rest of it. That's helpful. And all the rest. I will sign off for now. I hope you've enjoyed the stream, and I will see you tomorrow morning. Until later, my friends, I hope all's well. Cheers, my friends. Oh, Lisa, I didn't mean to. I don't mean to neglect you, Lisa Marie. I'm sorry. What'd you say? Sorry for the distractions. You said this channel's allergic to you. No, we're not allergic to you. At this point, you have to think it's on purpose. No, just as I'm bouncing between different things and responding to different messages, I don't respond to everyone, but it's not out of any personal spite. Sorry if you felt unwanted. It wasn't. Oh, with the gift memberships. Oh yeah, that's completely at random. I mean, I have no ability to control that. So I'm sorry about that. That's just at random, and it happens when it happens. Although, of course, memberships are only 99 cents a month. So if you don't get one as a gift, you could always buy one because they're literally the least YouTube will let me charge you. They could not be any cheaper, literally. So if you want to pay the 99 cents, it would be appreciated. It's only 99 cents a month. No muss, no fuss. So it's great. And of course, you can buy them for other people. So many people do. It's very, very generous. So just hit the join button, hit the link, and 99 cents a month. You're good to go. There's the link from Stream Elements as we speak. So you can hit that, and that'll be great. And for your 99 cents a month, you get some cool emojis. You get access to some member only content. Typically, like when I do gaming streams, they're then become members only. So you get access to that. And you get you get a uncivilian status on the Discord if you're signed up for Discord. So you get uncivilian status there. That's kind of cool. And generally my love. So all that good stuff. All right, I'm gonna sign off for now. Hope all's well. Cheers, my friends, and goodbye.